Thank you all for being here. I'm Kevin Johnson, Dean of the Law School and co-director of the Aoki Center on Critical Race and Nation Studies. And I appreciate you joining us for the latest installment of the Racial Justice Speaker Series. The series is sponsored by the School of Law and the Aoki Center. And we began the series in the fall of 2020 as a way of helping our community process the killings of George Floyd, Breonna Taylor, and others, while also addressing the broader implications of systemic racism in U.S. society. We also wanted to widen the perspective to show how racism, in its terrible insidiousness, affects all areas of the law and society and many different groups. Our Racial Justice Speaker Series thus far has encompassed many subject areas, including family law, corporate law, immigration law, criminal law, the legal history of anti-Asian discrimination, anti-Muslim laws and policies, and much more. And we're very lucky, honored today to have Tom Saenz, the President and General Counsel of the Mexican American Legal Defense and Educational Fund, here to talk with us. Now, MALDEF is perhaps the leading Latino civil rights organization in the United States. And Tom has led MALDEF since 2009. And he leads its national efforts to promote the civil rights of all Latinos in the United States. Tom previously practiced civil rights litigation at MALDEF for 12 years, including 4 years as vice president of litigation. He is MALDEF's lead counsel in the successful challenge, an uphill battle, really, to California's Proposition 187. He also led numerous civil rights cases in the areas of immigrant rights, education, employment, language rights, and voting rights. Tom has been honored and recognized on too many occasions to mention here. I will mention that he was born in Southern California. He graduated with 2 degrees from Yale, and he is an amazing speaker as well as litigator and civil rights activist. Please join me in welcoming Tom Saenz. His talk today is entitled Status Report on Latino Civil Rights After 20 Years as Nation's Largest Minority Group.
Good afternoon, everyone, and thank you, Dean Johnson, for the generous introduction. It's a great pleasure to join you for this series about racial justice issues, which remain prominent in our headlines, remain prominent in our politics, remain prominent in the law, and are likely to retain that status for the foreseeable future. I would be remiss if I didn't begin by recognizing an important anniversary this week of a case that was brought by Latino plaintiffs to try to address the ongoing critical issue of education equity. So I hope you all are aware that yesterday was the 50th anniversary of the U.S. Supreme Court's decision in San Antonio Independent School District versus Rodriguez. And if you're not aware of the case, I urge you to look at it. It is a case in which Latino students and their parents were challenging the deep inequities in the way that the state of Texas will also be a theme throughout today's talk, going back at least 50 years, if not much longer. But the state of Texas had a system of financing public schools that rested almost entirely 50 years ago on local property taxes. The result, of course, was that there were dramatic differences in available per capita resources based on what school district you were in, and more specifically, what was the property wealth of that school district. And this all overlaid on a history in Texas of school districts being created for reasons of maintaining segregation rather than for any pedagogical or other education-related rationale. So even within a city like San Antonio, large, but at the time, 50 years ago, one would have expected it to have one school district. Instead, it had multiple. And so the distinctions between very small school districts, even within the state of San Antonio, were really extreme. Result, of that case, unfortunately, as I hope some of you will remember, is that a majority of the Supreme Court concluded that education is not a fundamental right under our US Constitution. Now, at the time, less than 30 years after Brown versus Board of Education, that was a surprise, certainly to the litigants and certainly to many, many others, because in Brown versus Board, as you all will recall, the justices were so eloquent about how critically important public education was to the nation, how critically important it was as a unifying force, as a training ground for future citizens and leaders. But after all of that eloquence 19 years prior, bare majority Supreme Court 50 years ago said education not a fundamental right under our Constitution. The result, of course, we still suffer from today is that access to federal courts to address education equity issues is extremely limited, even today. And so we end up in state courts under state constitutions arguing, generally successfully. MALDEF argued this a few years ago for the first time in New Mexico and established a precedent there that the New Mexico state constitution does view education as a fundamental right and further guarantees an adequate and equitable education from kindergarten through 12th grade. That was one of now the vast majority of states that have had such a judicial development. But as I said, that happened several years ago. To give you the update, we're still fighting today to have that decision adequately implemented in the state of New Mexico, a blue state that has both a legislature and now governor who are progressive, but the difficulties in obtaining the necessary resources in a context of constrained budget are such that even in states like New Mexico, we and other education advocates end up fighting for years and years about implementation. Indeed, the follow-up to the San Antonio Independent School District case from 50 years ago at MALDEF was the Edgewood cases. Edgewood being one of the districts that faced the severe discriminatory effects of the financing mechanism. And the Edgewood cases, I say plural, because MALDEF has had to pursue in state court at least 6 cases in the last 40 years to attempt to increase gradually the equity of resources available to schools in Texas. Now, why is Texas so important? You all know why, but it's a good transition to explaining my premise here today. Texas is so important back then and now because of the large and increasing size of the Latino population. So today, Texas, the second most populous state in the country, matches California in having a population that is now 40% Latino in composition. To reiterate, our 2 most populous states in the country are now each 40% Latino in population. But that is just one illustration of the broader theme that came out of the 2020 United States Census. I'm sure you all will remember that the headline when the results were released late in 2021 was that Latinos, although only 19%, I say only 19 to illustrate this point, accounted for 51% of the growth of the entire nation's population between 2010 and 2020. I say only because 19 accounting for 51% of the growth is an extraordinary illustration of how the Latino community is growing in comparison to all other communities in the United States. But 19% is an extraordinary number in and of itself. It now means that greater than 1 in 5 Americans in 2023 is Latino. And if you remember the headline from 2020 about 51% of the growth in the Latino community, you may not remember what was released a few months later. Following every census, the Bureau engages in study to determine what was the undercount and in some communities overcount reflected in the census data they had released. And a few months later, that didn't get the headlines, the Bureau indicated that the Latino community had the highest undercount of any racial ethnic group in the country. So that 19%, that 51% of growth likely underestimates the actual contribution of the Latino community to the growth of our country in the decade between 2010 and 2020. The undercount was 4.9%, according to the Bureau's estimation. Again, much higher than any other racial ethnic community, a subset of one other community, namely Native Americans who reside on reservations, had a slightly higher undercount. But Latinos had the highest undercount of any racial ethnic group in total in that census. Now, we can talk, I could probably talk for hours about why that undercount likely occurred. It was also a dramatic increase from the undercount seen in the Latino community in 2010 and in 2000. So I could talk for hours, we could all talk for hours about the likely reasons for that undercount, what triggered the non-participation of Latino households. A lot of it had to do with intentional and unprecedented manipulation of the census by the Trump administration with a goal, a specific goal of reducing the count of the Latino community. Just recite quickly the attempted addition of citizenship question at the last minute. We now know from the hard drive belonging to a deceased Republican operative that the whole goal of adding a citizenship question was to reduce the Latino count. But Trump added to that by later seeking to obtain data on the number of undocumented immigrants in each state in order to take that number out of the total population that would then be used to reapportion the seats in the House of Representatives, and followed by a directive from the president to the Bureau to produce for him an index, a measure of all non-citizens, undocumented and documented, including green card holders, a measure of all non-citizens in the country, so he can make that data available to line drawers who might have an interest in discounting all non-voters in equalizing the size of electoral districts. Again, the purpose of that, both because excluding non-voters takes out anyone under 18, but also because it takes out non-citizens, the main effect and the main intent behind that would be to reduce the count of Latinos used to create new districts, whether at state legislature, school board, city council, etc. But despite those efforts, we saw this incredible increase in the Latino population. And as we look forward, that will only become more pronounced. Today, more than 1 in 4 of every public school student from kindergarten through 12th grade nationwide is Latino. 1 in 5, the total population greater than 1 in 4 of those of school age enrolled in public schools across the country. That is then a precursor of what we will see in the future, which is increased growth of this Latino community. But as the dean indicated in introducing my talk and the title today, this is also not new. What came out of the 2020 census is not a new phenomenon in this country. Indeed, January of this year marks 20 years since January of 2003, when the United States Census Bureau reported publicly that it had concluded that Latinos sometime in 2002 had surpassed Blacks to become the largest minority group in the country. 20 years ago, at least, announced 20 years ago. So this phenomenon of the growth of the Latino community has been with us for at least a quarter century, if not longer. And that, with that, I mean a national level emphasis a national level effect of the growth of the Latino community. What does that mean? I've had the great privilege of, as you've heard, for the last 13 and a half years to lead MALDEF, the nation's leading Latino legal civil rights organization, since its founding in 1968, some 55 years ago. What does it mean to lead a Latino civil rights organization in a context of being not only the largest racial ethnic minority in the country, but also projected to be an even larger proportion, unprecedented in modern times, proportion of the US population comprised of one racial ethnic minority group? Well, we certainly know some of the ramifications of that. The so-called Great Replacement theory, adopted from Europe, where it was targeting another community, but somehow resurfacing here in the United States in the hands of some irresponsible political leaders who ham-fistedly refer to it in different terminology, but the ideology of the Great Replacement theory is there. Great Replacement theory is not discussed in the media today as focused on the Latino community. It's discussed as focused on all communities of color. But I want to assert to you today that the Great Replacement theory is entirely about the Latino community. It is the community that is growing to such an extent that it becomes a threat to the continuation in office of certain entrenched political forces. It is the community that by and large is stereotyped as being immigrant, even though the Latino community has been here since at least the middle of the 19th century in very significant numbers. It is the community that Donald Trump slandered in announcing in June 2015 his candidacy for president. It is the community that he slandered by focusing on immigrants from that community and calling them all criminals. Well, to be fair, he said a few of them were likely good people. The Great Replacement theory asserts that there is some conspiracy to take power through the importation, the immigration of large populations, in this case, the Latino population. And we in California, certainly the dean knows this, he knows it perhaps better than most because he's written about this. But we see that the Great Replacement theory is simply the Reconquista theory that was prevalent in California in the 1990s, updated and given a newly adopted name, as I indicated, from where it was developed in Europe. Many of you won't remember the Reconquista theory that was prevalent in this state during the spasm of anti-immigrant lawmaking that culminated in the enactment of Proposition 187 in 1994. The Reconquista theory was an assertion by some of the main proponents of Proposition 187, who, when they were confronted with all the policy arguments against enacting that initiative, would inevitably, and I can say this because I observed it personally on several different occasions with several different proponents of that initiative, when confronted with all the policy reasons not to adopt the law, they would inevitably end up by telling folks to send a message to Washington, D.C., because we need that message sent because of the Reconquista. And the Reconquista theory was that Mexico was conspiring with Mexican Americans to take back the portions of the United States that had been seized at the end of the mid-19th century United States-Mexico War. That Reconquista is a precursor to the Great Replacement theory. I will quickly note that in some ways, the Great Replacement theory is more insulting because at least in the Reconquista theory, Latinos, Mexicans and Mexican Americans were driving the alleged conspiracy. Under great replacement theory, we now are simply pawns, tools of some other force, not Latino, portions of the white community viewed as treacherous, who are driving that conspiracy. So it still is clear through line from one to the other. I just note that the modern version makes Latinos look even less as though we are agents of our own futures than Reconquista. But beyond that negative repercussion, what else does it mean to do civil rights, racial justice work under the law in this context of 20 plus years as the nation's largest minority group? Well, first, it means that we as a nation need to focus greater attention on the Latino community and its role in the future development of racial justice in this country. And it is here that I have to reiterate what I have done publicly to some notoriety in certain circles, which is to call out the Biden administration for its failure to adequately represent the growing Latino community in its unprecedented diversity of judicial nominations. And I congratulate the Biden administration and applaud its efforts to increase diversity and increase racial minority presence on our federal bench. And it has done great work with respect to the Black community. It has done great work with respect to the Asian American community. And it has even done pretty good work for the much, much smaller Native American community. Now, what do I define as doing good work? In the case of each of these populations, the Biden administration has appointed judicial candidates from those communities at rates that are higher, substantially higher. In some cases, 2, 3, 4 times the proportion that that group represents in the total population of our nation. The one minority group that has not experienced that kind of effort from the Biden administration is the Latino community. Today, Latinos represent 19% of the Biden administration's total judicial nominations through its administration. 19% matches, does not exceed, matches the census identified proportion of Latinos in the total population. But we are now 3 years past the census with a growing community. And we know that that 19% was already an underestimate because of the significant undercount. So 19% in 2023 is actually a continued underrepresentation of Latinos in the federal judiciary. Even if you give them credit for matching the 2020 census population, as I told reporters, it's wonderful that they've stopped digging the hole. But they've done nothing for the Latino community to fill the substantial hole that is Latino underrepresentation on the current federal bench. But as I've also said, these numbers are particularly disturbing because today, in 2023, the Biden administration, like its predecessors of either party, seek to appoint younger nominees who will serve as life tenured federal judges for a significant number of years into the future. A judge appointed today is likely to serve 25, 30 years on the federal bench. Remember what I told you about our school population. In 25 or 30 years, Latinos will be a much, much higher proportion of the population, and therefore will be even more prominent as litigants, as attorneys, as commentators, as legal reformers in the future. We've already seen Supreme Court's docket in the last several years that the Latino community is more and more a central element to critical civil rights cases, even if they don't fall within what would traditionally be viewed as Latino civil rights. Again, it's no accident that so much of the controversy about choice, reproductive choice, comes out of Texas, Florida, two very large Latino populated states. One example of what we will see, not just next year, but in 25 years, it will be multiplied even more. That's the concern about representation on the federal bench. What the Biden administration is doing by leaving us behind is not forward-looking from any definition of the term. So we have to, as a nation, focus more in a forward-looking way, anticipating what our population will look like in 25 years, create the infrastructure, including judges, for that future era. Especially because we are appointing judges who will be younger and younger and sit on the bench longer and longer. But I would also say that this status that we've now held for over 20 years also creates a responsibility for Latino civil rights lawyers and lawyers of all races who focus on Latino civil rights to take the lead in shaping a new era of civil rights protections, a forward-looking era of civil rights protections. Now is the time, if only because the Supreme Court has already, in its rulings, threatened long-standing civil rights protections in this country. And we know that shortly, in all likelihood, it will do so again and will match its recent overturning of a 49-year-old precedent in Dobbs with overturning a 45-year-old precedent emanating from this institution in Bakke. So the pushback, the retrenchment, is not just an imperative, but an opportunity to craft a civil rights law that will serve all futures. And the Latino community has a particular responsibility there. Very briefly, I want to explain why I think we are well situated to lead in that regard. In my view, the history of Latino civil rights in this country is of over decades struggling to take the reality of discrimination as experienced by Latinos and Latinas in the United States and try to have them fit civil rights laws and doctrines that were developed for a related but different context faced by Black African-American citizens under Jim Crow. Just to give one example, many of you, I hope, are familiar with the case of Hernandez versus Texas, the first major Latino civil rights case to come to the US Supreme Court, the exact same year as Brown versus Board of Education, decided in the same month as Brown versus Board, decided like Brown by a unanimous court in an opinion issued by the Chief Justice Earl Warren. Hernandez versus Texas was grappling with the state of Texas's clever way of attempting to deny an 18-year-old precedent established in 1936 in Norris versus Alabama for the African-American community in relation to jury exclusion. Norris had established the rule of exclusion, which said if you have a pattern of complete exclusion from juries going back many, many years, you need not come up with additional evidence of intentional discrimination to establish unconstitutional exclusion from the jury. That rule of exclusion, put in place in 1936, precipitated a change in how Texas viewed the Latino community, the Mexican-American community, and the state began to characterize them as white. And in Hernandez versus Texas, the state of Texas asserted that in fact, Mexican Americans were white, and therefore their exclusion from juries was not racial exclusion, and therefore they could not avail themselves of the Norris versus Alabama rule of exclusion, but would have to demonstrate intentional discrimination to challenge exclusion from juries. In its even more crass terms, the assertion was Peter Hernandez cannot challenge his jury as not including his race because he is Mexican American in Texas, therefore white. And lo and behold, his entire jury is white. Of course, none of them Latino. That first case going to the Supreme Court was the Latino community grappling with discrimination by proxy, racial discrimination, but in this case, characterized, and indeed I would assert mischaracterized by the state of Texas as being ethnic intra-racial discrimination, a proxy that then they attempted to create as an exception to a rule established for the context of race discrimination. But that epitomizes the struggle over years of taking discrimination experience in the Latino community under other proxies like language, like immigration status or assumed immigration status, like other characteristics tied to a lack of assimilation, the right wing would call it. But proxy discrimination faced by the Latino community does not fit easily into a construct that focuses specifically on racial discrimination. And so the Latino community has struggled over decades to fit its pernicious discriminatory experiences into a framework not made for those experiences. That experience enables us to look to the future and derive new approaches that should not just answer the discrimination experienced today by all groups, but irrational discrimination of the future as it may manifest and affect folks of all races. I'm going to give you two quick examples. A forward-looking theory of discrimination means fighting today for what the problem will be in the future. I'll give you one example from MALDEF's current docket. We have a number of cases challenging discrimination by employers against recipients of DACA, Deferred Action for Childhood Arrivals. And I credit Leticia Salcedo from this institution as she is shepherding many of those cases today through our court system. But I've been asked, why are we focusing on this issue? The number of DACA recipients is significant, but still not in the context of the large and growing Latino community as significant as other cases might be. But we do these cases to establish a precedent, not for today, but for the future, when a legalization program will eventually be enacted. And that program will include a period of conditional immigrant status, as it did following IRCA in 1986, before obtaining lawful permanent residence. And because that legalization program will be politically controversial, there will be employers around the country, small and large, who will seek to act out their political views by saying they will not employ those with conditional immigrant status. So the work we do today for work authorized DACA recipients is not just for those recipients and their colleagues, but also for a future much larger millions of folks in conditional immigration status as a result of a legislated legalization program. I'm going to give you one more example before ending, and that is what we have done at MALDEF together with others in response to one of those retrenchments by the US Supreme Court, a case that will celebrate, well, celebrate's not the right word, that we will commemorate its 10th anniversary in June of this year. It's a case of Shelby County versus Holder. To remind you, Shelby County was a case where the Supreme Court majority, a bare majority, struck down what had, until that point, been characterized with great accuracy as the most effective civil rights provision in our nation's history. A provision of preclearance of voting-related changes in jurisdictions with a history of voting discrimination and a history as a result of lowered participation of voters. So those covered jurisdictions, mainly states in the South, but also including Texas, Arizona, and parts of California, had to have their voting related changes reviewed by either a district court in Washington or the Department of Justice, reviewed to determine if they were intentionally discriminatory or would likely lead to going backwards in voting rights for minority groups in that jurisdiction. Supreme Court struck that down, the majority struck it down for a number of reasons that I won't go into today. But it did leave open the prospect of congressionally enacted successor coverage formulas. And so the civil rights community worked on coming up with a new geographic formula that would reflect more contemporary indications of discrimination in a jurisdiction and therefore subject it to preclearance. But MALDEF initiated, with the great help of other allied organizations, a supplemental proposal for preclearance coverage that has come to be called known practices coverage or practice-based preclearance. This is a different model of preclearance that doesn't focus on a history of any specific jurisdiction, but focuses on a history of practices that have been used throughout the country historically to reduce minority voting power. And it subjects those practices like annexations, de-annexations of particular communities to a city, county, or otherwise. Includes things like reverting from districted seats to partially at-large elections. But these practices known to be used to restrict the power of growing minority groups would then be subject to preclearance wherever they occur in the country. The only exception being those limited jurisdictions that are so completely of one race that there would be no implication for voting rights. But every other jurisdiction with diversity across the country would have to subject these specified practices to preclearance. Now, we came up with this approach to supplement the geographic approach because we recognize the growth of the Latino community and the Asian American community in other contexts meant that they would reach critical mass such that the powers that be would fear them and would take steps to block them from gaining increased political power. And they would do so by adopting these practices. And we proposed this supplemental formula out of a concern that we couldn't wait for those jurisdictions to acquire the history of discrimination documented in court to stop them from taking steps to stem Latino, Asian American, or any other growing minority group's power. So known practices coverage is a forward-looking attempt to not just work for today, but for the future and those groups that may grow to be a threatening size to the powers that be in the future. So it is this mixture of focusing today on adequate representation in the infrastructure, including the federal judicial infrastructure, combined with looking for new civil rights approaches that will answer both anticipated and unanticipated racial justice and other civil rights issues of tomorrow. In my mind, these two together characterize what it means at MALDEF, what it means in the context of civil rights for Latinos to have been for more than 20 years the nation's largest minority group, and anticipating that those public school students greater than 1 in 4 today will be taking on an even greater role in racial justice and other issues, other policy issues of the future. Thank you.
We have time for questions. No questions?
I'll answer any questions. I don't have to read to what I said. I'll just make it up. I don't know the answer.
Why is the Biden administration not appointing Latinos in sufficient numbers, you think?
Well, I think it's a matter of focus, first of all. There's a clear focus in this administration on increasing Black and Black women in particular representation on our courts, and that's very powerful and important. But it does mean that he's leaving behind this growing and significant community. Just to give a little more detail, in his administration, there have only been five Court of Appeals judges appointed who are Latino, and only one of those is a woman. So in over 2 years of appointments, 118, I think the latest number of confirmed judges, only one Latina to a Court of Appeals anywhere in the country, that in the Second Circuit. So I think it's focus. And I also think, candidly, that the president himself does not have sufficient experience and affinity with the Latino community. He's confessed that to some extent. And that's a problem if you don't have the right people he's appointed involved in making these decisions to counter that lack of familiarity and affinity in the president, in the Oval Office itself. I'm not sure how we get around that. Certainly I have tried one approach that's aggressive in public and received plenty of criticism about that. But I do think it's caused some changes in what otherwise might have been.
Oh, that was the same question.
Okay.
Sorry.
Besides DACA and voting rights, what other public policy priorities does MALDEF have, or that you're focusing on as you look at the next year or two?
Sure. Well, we are certainly very concerned about the anticipated outcome of the Harvard UNC cases before the Supreme Court. And we come to that with experience with Proposition 209 here in California. So my immediate concern is that when these decisions come down, and based on when they were argued, I would assert it is very likely to be well prior to the end of June. I think everybody assumes they hold all of the civil rights cases till the end of June. But given how early Halloween these cases were argued, I think we have to expect a decision sooner than that, perhaps before the end of April. And my immediate concern is what we saw with 209 is there was a dramatic overinterpretation of the effect of 209. And we will see the same with respect to these decisions. They will be overinterpreted. Some will do that because it coincides with their political interests. Some will do it simply out of excess caution. But we have to be prepared for a backlash that will assert initially that the decision means you can't talk about race. You can't talk about racial disparity. You can't look at racial disparity and consider it as you adopt policy positions. And they will assert it goes way beyond higher education. Others will assert that the case actually provides now constitutional legal support for their hostility to ethnic studies. Both of these things are false. No matter what this Supreme Court, as extreme as it may be, no matter what they decide in these cases, it will not mean you cannot talk about race or consider racial disparity. It will not mean anything about curriculum, including ethnic studies. But there are those who will assert that. In California, my view is we really were hamstrung by that for almost 7 years. The assertion that you can't talk about race, you can't think about racial disparity in policymaking across the board. So that's a major consideration at this point in time. I would have to add, we are really concerned about how workers in today's economy are faring, especially in a context where so much is dependent on federal enforcement rather than private actors, and the extent to which that federal enforcement is not matching the changing workforce. And that's both changes in the nature of work, right? Stuff we've seen, including the gig economy, et cetera, but also the composition of the workforce. I mean, I am pleased that Julie Su will become Secretary of Labor, barring any extraordinary problem in the US Senate, because she comes from California and has an understanding, an experiential understanding of the changing workforce. That's very good news. But if you look at the rest of the Department of Labor, those with experience from the West, those with experience with the Latino community are few and far between. We still have no EEOC commissioner who is Latino. That goes back now to before the Obama administration, goes back to, I think, the Clinton administration. And that's very troubling when Latinos are now 1/5 of the workforce. But it's both the way work itself is changing and the composition of the workforce that raises concerns about having to rely so heavily on government enforcement, whether that's federal or state, with respect to critical issues, whether it's wage and hour or most particularly occupational safety and health, which is almost entirely left to administrative enforcement. And we see dramatic impacts in the Latino community and have for decades. So that's a little of what we're looking at. Obviously, we also have our eye on what the other side may be doing in the realm of voter suppression, in particular states with large Latino populations, including notably Arizona and Texas. So we also have to have an eye on where things may be going the wrong direction in states with substantial Latino populations.
Two quick questions. One, I was wondering if you see a through line between the judicial nominations and, say, current immigration policy in the Biden administration and the asylum policy. And secondly, in your comments on DACA and employment discrimination, has there been, I mean, if I heard you right, you were describing that as like a proxy for race, ethnicity discrimination. To what extent have there been efforts or any kind of receptivity to making that sort of form of work authorization something that would be protected, or a non-discrimination provision being part of an extension of work authorization protections at a level in the state?
So I'll answer that first. So yes, I mean, our hope would be that a very clear and explicit protection would be a part of any legalization program. Certainly it was a part of IRCA. Problem is that IRCA hasn't changed. And so the specific streamlined mechanism to challenge discrimination is not available to DACA holders in particular. It's only available to lawful permanent residents, asylees, refugees, and that's just because IRCA's language has not been updated. That then gets used by the other side as a potential response pending before the Fourth Circuit as we speak, that somehow the establishment of that mechanism that excludes DACA holders simply because of the passage of time precludes them using Section 1981, a pre-existing statute, to challenge employment discrimination. So we do need to tailor the anti-discrimination provision in any legalization program to today and tomorrow. And with respect to your first question, I think that the lack of familiarity with the Latino community extends to a lack of familiarity with the immigrant Latino community. So yes, there is a connection. That said, there is plenty of blame to be spread around. And I am not one who would lay the blame entirely at the feet of the Biden administration on where we are. There are obviously other significant players, including Democratic leaders in both houses previously, but most notably the simple fact that we have faced now for far too long a partisanized issue on immigration where there is no deviation, virtually no deviation on the Republican side from a very hardline anti-legalization stance. And that's markedly different from what we've seen historically. IRCA, signed by President Reagan, negotiated in a bipartisan manner, including leaders from both parties, was the previous example. 1990, the last significant immigration-specific act, bipartisan. But we haven't seen that in about a quarter century. And that is a major problem and an ongoing one. And so, while I do see a connection between the lack of familiarity, affinity, there's plenty of blame to go around.